Hello everyone, welcome to Courts Today by Livelaw, your one-step destination for the latest and fastest legal updates. I am your host Urvashi Chauhan, bringing you day-to-day happenings, landmark judgments, crucial rulings and expert insights into the world of law. Starting today with an update on the Bihar Caste survey case. If you recall, based on the data from the Caste survey conducted in 2023, the state of Bihar passed the amendment laws increasing reservation for backward classes, scheduled tribes, scheduled castes and extremely backward classes to 65% from 50%. Last month, the Patna High Court, while deciding a PIL, struck down the Bihar Reservation Amendment Acts for being unconstitutional and in violation of Articles 14, 15 and 16 of the Constitution. I must tell you here that the Apex Court in various judgments has laid down the principle that reservations should not exceed 50%. These judgments stress the importance of maintaining a balance between providing equal opportunities to all citizens and making special provisions for backward classes. The new development in the matter is that today the top court admitted the petition filed by State of Bihar challenging the High Court's order which had set aside the amendment laws. Senior Advocate Ramdev for the State of Bihar requested for a stay of the High Court's judgment. He stated that the Supreme Court has passed an interim order in a similar law relating to the state of Chhattisgarh. Solicitor General Tushar Mehta submitted that interview process for employment were underway as per the new laws. However, the bench comprising CJI Chandrachud, Justices JB Pardewala and Manoj Mishra declined to grant interim relief and listed the matter for hearing. The Supreme Court has today dismissed a plea by the Enforcement Directorate challenging Jharkhand High Court's judgment of 28th June which granted bail to Jharkhand Chief Minister Hemant Soren in a money laundering case related to an alleged land scam. Soren, who was arrested in January this year, is being investigated for money laundering charges in connection with an illegal mining case as well as an alleged land scam in Ranchi. ED is investigating both cases and contends that approximately 8.5 acres of property in question constitutes proceeds of crime. Soren was granted bail by the High Court while concluding that based on the overall evidence and likelihood, there was no direct or indirect proof that Soren was involved in acquiring, possessing or hiding the 8.86 acres of land related to the proceeds of crime. The state opposing the same approached the Supreme Court. Today, Additional Solicitor General S.V. Raju took objection to the High Court's disbelieving of witnesses' statements recorded by the ED under Section 50 of PMLA. But in response, Justice Gawai said that the order of the High Court was a very well-reasoned one. Though the ASG tried to press further, also claiming that there are documents corroborating ED's case, but the bench was unmoved and dismissed ED's petition. The Supreme Court today issued notice in a PIL seeking directions to the Bihar government for a thorough structural audit and constitution of a high-level expert committee to identify any weak bridges that might need to be demolished or strengthened. The petition has been filed in the wake of reports regarding the collapse of 9 bridges recently, including under-construction bridges. It highlights the multiple bridge collapse around river areas, including the Araria, Siwan, Madhubani and Kishanganj districts. The petitioner has sought real-time monitoring of the bridges based on the same methodology developed by the Ministry of Road Transport and Highways, Government of India, through its policy dated 4th March 2024 for preservation of national highways and centrally sponsored scheme. The bench led by CJI DY Chandrachud and comprising Justices JB Pardewala and Manoj Mishra agreed to consider the matter and issued notice to the state of Bihar. The Supreme Court bench of Justices B.R. Gawai and K.V. Vishwanathan today posted the petitions filed by former Delhi Deputy Chief Minister Manish Sisodia seeking bail in the liquor policy case to 5th August. The bench adjourned the hearing after Additional Solicitor General S.V. Raju sought time to file counter affidavit on behalf of the Enforcement Directorate. He told the bench that the CBI has already filed its counter, which has not come on record. Sisodia has filed 2 petitions seeking bail in the cases under the Prevention of Corruption Act and the Prevention of Money Laundering Act, which are being handled by the CBI and the ED respectively. On 4th June this year, the Supreme Court had disposed of Sisodia's earlier bail plea after taking on record an assurance given by the Solicitor General that the charge sheet in the liquor policy case would be filed on or before 3rd July. At the same time, the court had granted Sisodia liberty to revive his prayers for bail after the final complaint was filed. Accordingly, in July, Sisodia's counsel mentioned his application for urgent listing before the CJI. During the brief hearing today, the ASG objected to the maintainability of the new petitions filed by Sisodia in the Supreme Court. He submitted that the 4th June order of the Supreme Court only enabled Sisodia to file fresh bail applications in the trial court and not in the Supreme Court. Senior advocate Abhishek Manu Singhvi for Sisodia objected to the submissions, terming it very unfortunate. The bench then pointed out that in the 4th June order, there is consideration on merits and it granted liberty to Sisodia to revive his bail pleas once the CBI or ED filed the charge sheet. The bench further pointed out that the period of 6 to 8 months fixed by the Supreme Court for completion of the trial as per the order passed in October last year was already over. In the next update, the top court has today issued notice in the petition filed by Sharad Pawar's NCP faction challenging refusal of the Maharashtra Assembly Speaker to disqualify members of the Ajit Pawar faction of the Nationalist Congress Party. The issue arose when a section led by Ajit Pawar and Praful Patel broke ranks with the NCP Supremo Sharad Pawar and joined hands with the BJP and Shinde Sena. Ajit Pawar was sworn in as the Deputy Chief Minister and 8 other NCP MLAs took oath as ministers in the Eknath Shinde-led government in July 2023. If you remember, in February this year, the Maharashtra Assembly Speaker Rahul Narvekar refused to disqualify MLAs who supported Ajit Pawar following the rift. He relied on ECI's verdict recognizing Ajit Pawar's faction was the real NCP. While refusing to hold the actions of Ajit Pawar group as amounting to defection as per the 10th schedule of the Constitution, the Speaker opined that they were in the nature of intra-party dissent within the NCP and the members of the party stood divided between the two leaders, that is the Sharad Pawar and Ajit Pawar. He had said that questioning the decision of Sharad Pawar and going against his wishes could not be seen as an act of defection or of leaving the party. Today, while hearing Sharad Pawar faction's petition, the bench led by CJI D.Y. Chandrachud clarified that the contentions about the maintainability of the petition will be decided along with the merits at the stage of final disposal of the case. It further clarified that the challenge will be heard along with pending petition of Shiv Sena Uddhav Thackeray faction, which challenges Speaker's refusal to disqualify MLAs belonging to Eknath Shinde group. The Delhi High Court has directed Yoga Guru Baba Ramdev to remove his statements claiming that allopathy was responsible for deaths of lakhs of people in COVID-19 and that Patanjali's Coronil is a cure for the virus. Justice Anup Jairam Bambani passed the order in the interim injunction application moved in a suit filed by various doctors' associations in the year 2021. The doctors' associations alleged that Baba Ramdev was causing misrepresentation to the public at large by spreading misinformation, promoting people to not get hospitalized by saying that allopathy was responsible for COVID deaths. The bench directed Ramdev to take down the offending content from social media within 3 days. It also said that in case Ramdev fails to take down the statements within 3 days, the social media intermediaries will take down the same. The Supreme Court today impleaded the Archaeological Survey of India in a plea seeking protection for centuries-old religious structures inside the Mehrauli Archaeological Park in Delhi, including the 13th century Ashik Allah Dargah and Chilagah of Baba Farid. The division bench of Justices Sanjeev Khanna and Sanjay Kumar were hearing an SLP against the Delhi High Court's order, which refused to pass specific directions for protecting the structures. The court sought status reports from the ASI and the National Monument Authority. The plea before the High Court raised the apprehension that the Dargah and the Chilagah in Mehrauli will be demolished soon by the Delhi Development Authority in view of the fact that a 600-year-old mosque, Masjid Akhonji, was also demolished by the Delhi Development Authority in January this year along with various graves. But the High Court had disposed of the matter after recording the government authorities' undertaking that no protected monument or national monument would be demolished. Challenging the High Court's order, an individual named Zamir Ahmad Jumlana has moved the apex court now, arguing against the demolition of the historic structures. Previously, let me tell you, the top court had directed the petitioners and authorities to make their representations to a court-constituted religious committee first. The decision taken by the religious committee was to be placed on record before its implementation. But today, the court was informed that the religious committee meeting had not been held. Therefore, the court relisted the matter in the week commencing 23rd September. In another update, the Karnataka High Court has urged the central government to amend Section 184 of Bharatiya Nagrik Suraksha Sanhita to provide that adult victims of rape be examined in hospitals only by female doctors so as to protect their right to privacy. A single-judge bench of Justice M.G. Uma was hearing a bail application filed by an accused charged for the offences of rape and attempt to murder under the IPC. The court rejected his bail plea on considering the medical records of the victim and accused who suffered injuries at the hand of the victim during the incident. During the hearing, the court examined the medical records of the victim and noticed that a male medical doctor had subjected the victim to medical examination, and it lasted for about 6 hours without there being any explanation and without any opinion. I must tell you here that Section 164A of the CRPC provided that the victim of similar nature could be examined by any registered medical practitioner. This provision is now replaced with Section 184 of BNSS and has been copied verbatim in BNSS. Justice Uma said that the new provision had been copied without noticing the anomaly, which is causing great injustice and embarrassment to the victim of sexual assault. Observing that medical examination of rape victims should always be victim-friendly, the court directed the central and state governments to ensure that till the amendment is brought, medical examination of rape victims be conducted only by or under the supervision of a female registered medical practitioner. Further, it has directed the authorities to educate and sensitize all stakeholders, that is, police officials, prosecutors, doctors, and other medical officials who respond to the victim, including judicial officers, on this aspect. And lastly, while hearing a PIL challenging Hindi titles for the new criminal laws, the Kerala High Court today asked if it has the power to direct Parliament to change the names of the enactments. The petition has been filed by an advocate stating that Hindi titles given to the new criminal acts contravene the provisions of Article 348 of the Constitution. Previously, it was argued that Hindi names of the new criminal laws create difficulty for non-Hindi speaking and violate their fundamental right to carry profession under Article 19(1)(g) of the Constitution. On the other hand, the council appearing for the Union of India submitted that names are given in English letters and even the script and contents of the enactments are in English. It was also argued that many enactments use terms like Bharatiya, Lokpal, Lokayukt, etc. in their names. The division bench comprising Acting Chief Justice A.M. Mustaq and Justice S. Manu, after hearing the parties, reserved the matter for orders. If you wish to know more details about the cases that I mentioned here, you can visit our website at www.livelaw.in. Stay ahead with quick legal updates only on Live Law. Do not forget to like, share and subscribe and support us. You can also support us by donating through the thanks button at the bottom of our videos or consider becoming a member at just 89 rupees per month.